Welcome to our deep dive on the so-called 10-year immigration rule. To begin, we will clarify what this myth is, why it persists, and how scammers exploit it. Then, we will explain the real legal concept behind it. Cancellation of removal for non-permanent residents, and why success is exceptionally rare. Finally, we will provide practical steps to protect yourself and your family while avoiding unauthorized practitioners. Here is our roadmap. First, we will define the myth. Next, we will unpack the true legal concept, cancellation of removal for non-permanent residents. After that, we will discuss why approvals are rare. Then, we will highlight fraud red flags. Finally, we will cover protective steps and verify how to find licensed help. We will also include quick quizzes to reinforce learning. Before we proceed, please note this is general educational information, not legal advice. Immigration law is complex and fact-specific, and outcomes depend on individual circumstances and changing laws and policies. Always consult a licensed and verified immigration attorney about your situation. Let us clarify terminology. The so-called 10-year rule is not a visa, not a routine application, and not a shortcut to status. It refers to a specific form of relief called cancellation of removal for non-permanent residents, which may be requested only in immigration court after the government has initiated removal, also known as deportation, proceedings. Here is the reality. The 10-year concept is shorthand for cancellation of removal, a defense available only inside immigration court after the government starts removal proceedings. It is not a program one can simply sign up for. To even be considered, a person must be in proceedings and must prove all three elements: at least 10 years of physical presence, good moral character, and most critically exceptional and extremely unusual hardship to a qualifying relative who is a U.S. citizen or lawful permanent resident spouse, parent, or child. Even then, the judge has discretion, and approvals are rare. Many cases are denied, despite long residence and close family ties. Now, let us compare licensed attorneys and unlicensed notarios. Licensed attorneys have verifiable bar numbers, ethical obligations, and accountability. They analyze risks, explain legal options, and represent clients in court. In contrast, notarios and unlicensed consultants lack a law license, often make promises of guaranteed results or shortcuts, and may pressure individuals to take steps that expose them to enforcement. They frequently collect substantial fees without providing lawful representation. This table frames the three hurdles and typical evidence. First, 10 years of physical presence requires proof of continuous residence through records such as leases, utility bills, school or medical documents, and tax filings. Second, good moral character involves demonstrating positive conduct and the absence of disqualifying factors, often supported by background checks, tax compliance records, and community letters. Third, the hardship requirement is the most demanding, requiring detailed documentation that removal would cause exceptional and extremely unusual hardship to a qualifying U.S. citizen or lawful permanent resident spouse, parent, or child, supported by medical, educational, psychological, or country conditions evidence. Let us turn to hardship. The required standard is the highest in immigration law and is intended to be met only in truly extraordinary circumstances. Examples can include severe pediatric illness, complex disability care needs, life-saving medical treatment, or unique educational requirements that cannot be addressed elsewhere. By contrast, ordinary financial hardship, routine family separation, language barriers, and typical caregiver changes generally are not sufficient. Detailed and credible documentation is essential, and ultimately judges exercise discretion in deciding these cases. Here are safe steps. First, verify your representative's law license through the State Bar's website. Second, insist on a written agreement detailing services and fees. Third, avoid anyone who guarantees approval or claims a 10-year visa exists. Fourth, do not allow anyone to file documents that could expose you to immigration enforcement without the advice of a licensed attorney. Fifth, when in doubt, seek a second opinion from reputable nonprofits or legal aid. Finally, keep copies of all documents submitted in your name. Quiz time. The question is whether the so-called 10-year rule is a visa program one can apply for in an office or a defense used only in deportation court. The options are: a visa application anyone can file, a legal defense used only in removal proceedings, a work permit program based on long presence, or an amnesty after 10 years. You may pause the video now to think about the answer. We will discuss the correct answer in the next section. The correct answer is that it is a legal defense used only in removal proceedings. It is known as cancellation of removal, and it is not a visa. It is a narrow form of relief that must be requested in immigration court after proceedings have begun. Watch for these red flags. First, avoid anyone who guarantees results or promises an easy 10-year visa. Second, be wary of pressure to contact immigration authorities to start a case. Third, do not pay large sums in cash without receipts. Fourth, insist on a bar license and verify it. Refusal to provide one is a serious warning sign. Fifth, be cautious if you are told not to consult a licensed attorney. These are classic tactics of fraudulent operators. This timeline illustrates two pathways. On the first track, a person not in removal proceedings is scammed by a notario, is told to contact enforcement, is then placed in proceedings, requests cancellation of removal, and most likely faces denial and deportation risk. On the second track, a person consults a licensed attorney, undergoes a proper screening for lawful options, avoids unnecessary exposure, and pursues strategies for which they are actually eligible, thereby managing risk more effectively. The contrast underscores why unauthorized advice is dangerous. Here is the second quiz. The question asks, which relatives count as qualifying for the hardship requirement? The options are any family member, only U.S. citizen, or lawful permanent resident spouse, parent or child, friends or employers, or anyone in the same household. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is only U.S. citizen or lawful permanent resident spouse, parent or child. These are the qualifying relatives for the hardship analysis in this context. Even with qualifying relatives, relief is not guaranteed because the exceptional and extremely unusual hardship standard is very demanding. Let us separate myths from facts. The myth that living in the country for 10 years automatically leads to legal status is false. The reality is that this is a court defense with strict criteria. The myth that any hardship counts is also false. Only exceptional and extremely unusual hardship to qualifying relatives is considered. The myth that notarios can safely file these cases is incorrect. Only licensed attorneys should evaluate and advise on the risks. Finally, long presence does not guarantee success. Many cases are denied even after decades in the country. These are the key takeaways. It is not a visa, but a narrow court defense. Approvals are rare, even for people with long residence and close family ties. Do not enter removal proceedings simply to try for this relief. Avoid notarios and always verify that your representative is a licensed attorney. If a case is pursued, documented, and truly extraordinary, hardship is essential. To recap, distinguish myths from actual law. Understand the 3 hurdles and recognize that the hardship requirement is the most challenging. Learn to spot scam tactics and disengage immediately. For any personal decisions, consult a licensed immigration attorney who can provide tailored advice based on your specific facts. Thank you for watching. If you found this helpful, please like the video, share it with your community, and subscribe for more clear guidance. Share your questions or experiences in the comments. Your story may help someone else avoid a costly mistake.